Okay, welcome back. We are now in step 3, where we're going to talk about responding to a petition for dissolution or legal separation with or without children. First of all, keep in mind that when you respond, you have an opportunity to put up some defenses before you respond in full to the petition. And here are a list of those defenses. So one is lack of subject matter jurisdiction. Now, this definitely gets a bit complicated. If you don't think Arizona has jurisdiction over your divorce, that is a defense that can be alleged. Lack of personal jurisdiction. If you believe Arizona doesn't have jurisdiction over you or your spouse. If you think venue is improper, that the case shouldn't be in, for example, Maricopa County, but it should be in Pima County, that could be an improper venue defense. If you were not properly served with process, you weren't served by a process server, the certified mail, that wasn't done, you didn't sign an acceptance of service, that there is something wrong with service process, you can allege that defense. Failure to state a claim upon which relief can be granted. That gets a little complicated, but let's say that your spouse is asking to dissolve a non-covenant marriage, but you actually have a covenant marriage. You could say, hey, look, you failed to state a claim upon which relief can be granted. Now, when do you assert these 5, in any of these 5 defenses? Well, you would need to make a motion before filing a response to the petition, except that a motion for lack of subject matter jurisdiction may be made at any time. If a pleading sets out a claim for relief that does not require a responsive pleading, an opposing party may assert at trial any defense to that claim. Now, that is not the case here. The petition for dissolution does require a responsive pleading. And so as a result, if you wanted to raise any of these defenses, those should be raised prior to filing a response, except for lack of subject matter jurisdiction, which could be made at any time. All right, so the forms to draft an e-file to respond to a petition for dissolution or legal separation of non-covenant marriage with or without minor children. You're going to have your sensitive data sheet, your confidential form, and then your response to the petition, and then your parenting plan proposal if your case involves minor children, and a child support worksheet if your case involves minor children. So your parenting plan proposal and then your child support proposal, those would also be included with your response if your case involves minor children. When is the response due? If you were served in Arizona, then file your response within 20 days of the date you were served. If you were served outside of Arizona, file your response within 30 days of the date you were served. Let's look at the sample form for response both with and without minor children. So here on the left, we've got the response without minor children, and here on the right, we have the response with minor children. Now, both of these are for a dissolution of marriage. If you are looking at a legal separation, then use the response to petition for legal separation form. Okay, so fill out your contact information on the top. You're going to fill out the caption just as it is in the petition. So your spouse here, your name here, the case number, you'll have that at that point. So fill out your caption. Next is information about your spouse, information about you, fill those out. Then information about your marriage, fill that out, make the 90-day requirement. And now here in the response without minor children, we start getting into community property. But here in the response with minor children, we're getting into the kid-related issues. So domestic violence, the children common to the parties, pregnancy, summary of what I want or say concerning our minor children that is different from what my spouse said or asked for in the petition and affidavit. So anything different about the minor children, you can indicate that in these lines. If you need more room, you can do it on it, write that out on a different sheet or type it out and then say see attached. And then now we're getting into the property and debt section, and this is the same for the response without minor children. So first indicate whether or not community property was acquired during the marriage, and then if so, get into the real estate, what you want to happen with it, the household furnishings, the furniture and appliances, other items, retirement accounts, motor vehicles. So you're going to list out the property, indicate who you want to receive it and what you believe the current value is. If you want anything sold and split, you can write that in. So now here we're getting into separate property on the without children form. So that's up here. Here's the separate property on the with children form. Getting into community debts, separate debts, tax returns, spousal maintenance, pregnancy, other statements under oath. And then also you can indicate here how your spousal maintenance request is different from what your spouse asked for in the petition. Information about drug or alcohol convictions in the last 12 months, child support, other expenses. If you have a written agreement, the parent information program, there's your general denial. And then you get into the requests to the court. So what are you asking the court to order? So just fill this out according to your case strategy. And then if you have a written agreement, you can attach that. Here's the general request to the court. Sign before a notary. And that completes the response. Remember, if your case involves minor children, you also need to do a parenting time proposal. And here's what that form looks like. It's 10 pages. This is just the first page. You also need to do a child support worksheet. This is what the form looks like. Go back to the child support case strategy creation videos to see how to fill out this form. All right, and then as a review, when you're responding to the petition, whether you have a case with or without minor children, you're going to draft and file the cover sheet and sensitive data form, your response. And then if your case involves children, you'll do the parenting plan proposal and a child support worksheet with your proposed parenting plan and your proposed child support amount. What if no response gets filed? Or excuse me, we're going to do that in step 5 if no response is filed. Here in step 4, we're going to talk about what happens once the response is filed. Then what? Once you receive a copy of the response, because once the response is filed, a copy needs to be mailed to the petitioner. So once you receive a copy of the response, read the response, identify what is in dispute and what is not. Most likely, the court will set your case for a resolution management conference, also known as an RMC, approximately 40 days after the filing of the response. And you can start working on your Rule 49 disclosure statement. You can start working on your proposed resolution statement. We'll talk about those forms more in later videos, but those are things to start doing. And if you're in a position to do so, you could make a settlement offer at this point. So you can look through the petition and the response, see what's not disputed, and then also identify what is in dispute and see if there's room to make a settlement offer to resolve your case. Okay, so that wraps up this video about how to draft a response, what documents to file, and then what to expect after the response is filed. In the next video in the series, we will talk about how to pursue default in the event a response is not filed by the deadline.